Todd Blanche, who's already done the 10 best list, the 10 best reasons,
the 10 reasonable doubt reasons for reasonable doubt. Yeah.
Now he's come up with Michael Cohen is the gloat. He's literally the greatest liar of all time. He has lied to every single branch of Congress. He has lied to the Department of Justice. His words cannot be trusted, and I am going to end the summation the same way that I told you a few minutes ago, that I know you cannot rely on him. All those lies, put them to the side for just a moment. You cannot rely on him. All those lies under oath, all those lies, that is reason enough to walk away. He came in here, raised his right hand, and he lied to each of you repeatedly, making it personal, right? You cannot send someone to prison based on the words of Michael Cohen. It was a lot of evidence, but it is important to President Trump and his family, and it is clear to you all, you all have been paying close attention, and that is, as it's catching up, I have text from the court, very important. This isn't a referendum on your views of President Trump.
What's happening, people? Welcome to Jack Mockler again. After 5 weeks of testimony, prosecutors delivered 7 hours of closing arguments, methodically building an unassailable fortress of evidence, invoice by invoice, check by check, phone record by phone record, to convince a Manhattan jury that the documents alone were damning and sufficient to convict Trump on all 34 felony counts. The paper trail, they insisted, told its own unmistakable story. Across the aisle, Trump's legal team executed the strategy they had been perfecting since the first gavel fell. Their entire case rested on one man, Michael Cohen, the former fixer, the man who had once declared he would take a bullet for Trump before becoming his most persistent and vocal critic.
That's important to a Manhattan jury, right? This is not a referendum of President Trump. This is not a referendum on the ballot box. He's trying to take it out of the politics. And he's appealing to them and to their pride and pride of service, of public service, right? This is not a referendum on the ballot box. This verdict you're going to reach has to do with the evidence. He's telling them, of course, that's what the judge will tell them as well. The evidence that you've heard. And that's as far as they've gotten so far. But this sounds like a big wind-up for a jury that's been listening for a long time this morning.
I appreciate what Blanche did. He threw in about prison. First of all, Trump, that's not something the jury was not just not required to, should not be speculating about, number one. Number two, it's really inappropriate. Theoretically, the prosecution could object, or they just kind of let it go and maybe answer it later on, or have the judge respond to it during some curative instruction right before the jury goes out. But I agree with what Chuck said before. This is a little too cute.
Defense attorney Todd Blanche stood before the jury and did what defense attorneys do when their client's liberty hangs in the balance. He pointed at Cohen with theatrical disdain and called him a liar. Not just any liar, the greatest liar of all time. He even gave the accusation an acronym, GLOAT, because the defense presentation was operating on multiple levels: rhetorical, strategic, and theatrical. Their argument was simple and devastating in its simplicity. The prosecution's entire case depended on the testimony of someone no reasonable person should believe. Destroy Cohen, and you destroy the case against Trump. It was a gamble.
This is getting cute with these top tens and the gloat, greatest liar of all time. And it's really rich when you have someone who's accused of having an affair and multiple affairs and all sorts of fraud, to be saying that this other person is the greatest liar of all time. It's not lost on that jury.
I was going to say there's some competition for that title, but putting that aside, Andrea, Mr. Blanche is wrong as a matter of law. The jury can convict just on the testimony of Michael Cohen if they so choose. There's a standard instruction, I know in federal criminal law, that the jury can, if they find the testimony of a single cooperating witness credible, impactful, then that alone could be the basis for their conviction. They're not instructed to do that, but they're told it's an option. So if you believe Michael Cohen, then that could be sufficient.
And Todd Blanche has just sat down. He said, if you focus just on the evidence you heard in this courtroom, this is a very, very quick and easy not guilty verdict. Thank you. Joining us now, I want to bring in former U.S. Attorney Joyce Vance, who's been watching all of this and reading all of this. Joyce, what do you think of the defense's summation?
a high-stakes bet on the proposition that the jury would find Cohen so fundamentally unreliable that they would reject everything he touched, including the documentary evidence that surrounded his testimony. That clash, prosecutors armed with a mountain of paper, defense lawyers betting everything on destroying one compromised witness, represents one of the most consequential legal confrontations of the entire Trump era. And today, we are going to walk through every piece of it, every argument, every document, every moment that led to a verdict that will echo through American history. The New York hush money case against Donald Trump was built on a foundation of business records.
So, like Chuck, I'm not a big fan of listicles. It seems a little bit cute and pat. And it was much more structured than much of Todd Blanche's closing argument, which I took to have really 3 buckets of reasonable doubt. I heard him saying, you can't convict because these documents aren't fraudulent. Well, that's something that the prosecution will, I think, deal with pretty readily. Then he seemed to argue for a time that Donald Trump didn't have the intent to commit crimes, that he was too busy running the country to commit crimes. And I think we'll hear the prosecution say a lot about that too. Ultimately, it came down to this argument about Michael Cohen, with Blanche arguing you can't send someone to prison on the word of a liar like Michael Cohen. And again, the government will have plenty of responses. They'll say that they didn't pick Michael Cohen as a witness, that it was Donald Trump. And they'll talk about the fact that even people who have lied, who have demonstrably lied and been convicted of it, like Michael Cohen, can come back and tell the truth. And this, I think, is the signal weakness in this defense summation. They failed to confront the corroborating evidence that the prosecution put together before Cohen took the witness stand, leaving an opening for the prosecution now to come back and to tell the jury why they can trust.
Specifically, whether records maintained by the Trump Organization were falsified, recorded as something they were not, as part of a larger scheme to conceal payments that prosecutors argued were made for one purpose and one purpose only: to influence the outcome of the 2016 presidential election. The conduct at the heart of the case was straightforward. In the months before Americans went to the polls to choose their next president, Trump's then-fixer, Michael Cohen, paid adult film actress Stormy Daniels $130,000. The payment was made in exchange for her agreement to remain silent about an alleged sexual encounter she claimed to have had with Trump years earlier. Silence has a price, and in this case, the price was $130,000. After the election, after Trump had secured the presidency, Cohen needed to be reimbursed. The reimbursement came through a series of checks. Checks signed by Trump himself. Checks signed by other figures within the Trump Organization. And in the Trump Organization's internal records, those checks were recorded as payments for legal services. They were characterized as reimbursements to Cohen for legal work he had supposedly performed. The prosecution's argument was devastatingly simple. That characterization was false. Cohen was not being paid for legal work. He was being reimbursed for a hush money payment made to silence a woman whose story could have damaged Trump's electoral prospects. Recording the payments as legal services in the business records was falsification. Done with intent. Done with knowledge, done as part of a scheme to conceal what prosecutors characterized as a conspiracy to influence the 2016 election by keeping damaging information from the American people. That theory, falsified business records, hush money, election influence, formed the backbone of the prosecution's case, and it was supported by a specific documentary trail that became the centerpiece of the prosecution's closing argument. When prosecutors rose to deliver their summation, they did not engage in rhetorical flourishes. They did not attempt to create dramatic moments designed for cable news consumption. They did something more methodical and ultimately more devastating. For 7 hours, they walked the jury through the evidence, piece by painstaking piece. They showed the jury the invoices submitted by Cohen to the Trump Organization for the reimbursement payments. They showed the ledger entries. The internal Trump Organization records that recorded the payments. They showed the checks, some of them signed by Trump personally, bearing his distinctive signature in black ink. They showed the phone records, the internal communications, the email exchanges. And they argued that the combination of those documents, the invoices, the ledger entries, the checks, the internal communications, constituted a documented paper trail of a falsification scheme. Not Cohen's word alone, not the testimony of a compromised witness whose credibility could be attacked. Documents, signed documents, internal organizational records. Evidence that the prosecution argued did not depend on trusting any single witness, but instead told the story through the business records themselves. The story those documents told was one of deliberate concealment, a scheme that involved multiple people across multiple levels of the Trump organization, people who knew what the payments were actually for and who participated in recording them as something different. The documentary case, the paper trail, was what prosecutors called damning, and damning was a calculated word choice. They were telling the jury that the evidence on the documents was strong enough, clear enough, and documented enough that it should produce a conviction regardless of how the jury felt about any particular witness, even if they hated Michael Cohen, even if they believed he was the greatest liar of all time. The documents told the same story. Now let us turn our attention to the defense's strategy, because Todd Blanche's approach in his summation reveals everything about what the Trump legal team believed was their best and perhaps only path to a favorable outcome. Blanche led with a declaration. President Trump is innocent. 3 simple words, a direct statement of the conclusion he was asking the jury to reach, and then he built his entire summation around a single argument. The prosecution's case depended on Michael Cohen, and Michael Cohen was the greatest liar of all time. He actually used that phrase, greatest liar of all time. He gave it an acronym, GLOAT, because this was the kind of presentation where that kind of rhetorical device was being deployed. The entire structure of the defense summation was constructed around the argument that if you cannot trust Cohen, if Cohen is so fundamentally unreliable that his testimony cannot be credited, then the prosecution's case collapses. Because Cohen was the key witness who could speak to Trump's knowledge, Trump's involvement, and Trump's intent in the scheme. Without Cohen's credibility, the documentary record might show that false entries existed in the business records, but the prosecution would struggle to prove that Trump personally directed or approved the falsification with knowledge that it was being done to conceal an illegal scheme. The credibility question was central. It was the strategic battle that legal analysts had been focused on since the trial began. Cohen is, to put it gently, a compromised witness. He has pleaded guilty to multiple federal crimes. He has lied to Congress. He has a well-documented and bitter personal feud with Trump. He has a financial incentive through his book deals, his podcast, his public profile as a Trump critic to tell a story about Trump that is as damaging as possible. All of those things are true. All of those things were presented to the jury in excruciating detail by the defense. Blanche did not just call Cohen a liar. He went through specific instances where Cohen had been documented as lying in previous proceedings. He reminded the jury that Cohen had previously said under oath that Trump did not direct the payments before later reversing that position. He built a case that Cohen's credibility had been so thoroughly destroyed by his own conduct in his own prior statements that relying on his testimony to convict a former president was not something that a reasonable juror could do. That argument has real force. It is not a frivolous attack. Cohen is genuinely a problematic witness by any objective standard, and a defense team that can get 12 jurors, all 12, because a criminal verdict requires unanimity, to conclude that Cohen cannot be trusted has a viable path to defeating the case. But here is where the prosecution's counter-strategy becomes critical to understand. The prosecution did not build a case that depended on Cohen alone. They built a case that used Cohen as a witness to Trump's knowledge and intent, while surrounding that testimony with a documentary record that they argued was independently sufficient to establish the core elements of the offense. The invoices were real. The checks were real. They were signed by real people. The ledger entries were real. They existed in the Trump organization's actual business records. And the question of whether those entries were false, whether recording payments as legal services when they were actually reimbursements of hush money was a falsification, does not depend entirely on what Michael Cohen says about why the payments were characterized that way. It depends on what the documents themselves show about what the payments actually were for and whether that characterization was accurate. Prosecutors argued that the documentary trail was strong enough to establish the falsification independently, that even if the jury had serious doubts about Cohen, the paper record told a clear enough story to support the fraud finding. Whether the jury accepted that argument, whether they concluded the documents spoke clearly enough without Cohen, was a central factual question of the deliberations. One of the most remarkable moments in the entire closing argument period occurred when Judge Juan Merchan intervened during the defense summation. After Blanche deployed the GLOAT acronym and called Cohen the greatest liar of all time, the judge instructed the jury to disregard that specific comment as improper. That instruction from the judge is significant on multiple levels. First, it tells you something about the judge's assessment of the defense's conduct. Judges do not routinely instruct juries to disregard portions of closing arguments. It happens when a judge concludes that specific language or a specific argument crosses a line, is inflammatory, is improper as a matter of law, or risks confusing the jury in a way that could produce an unjust outcome. For the judge to specifically call out the GLOAT comment and tell the jury to disregard it suggests he found the rhetorical device inappropriate in the specific context. Second, the intervention focused national attention on the exact moment where the defense was most aggressively attacking Cohen's credibility. The instruction to disregard it did not make it disappear from the jury's minds. Jurors are human beings who cannot unhear something just because a judge tells them to disregard it. But it did attach official judicial disapproval to the most extreme version of the defense's Cohen attack. Third, it underscores something about how both sides were operating in the closing stage of this case, pushing limits, deploying aggressive rhetoric, doing whatever they believed gave them the best chance of moving 12 jurors to the verdict they wanted. This was a high-stakes case being fought at maximum intensity, and the judicial intervention was evidence of that intensity. The stakes of the verdict extended far beyond the specific facts of the case. The New York hush money trial was the first criminal trial of a current or former United States president in American history. That fact alone gives everything about it historic weight that transcends the specific business records and hush money payments at issue. The question being posed to the jury was not just whether Trump falsified business records. It was whether a former president of the United States, a person who held the most powerful office in the world and who was seeking to hold it again, would be subject to the same criminal laws that apply to every other citizen. Whether the principle that no one is above the law has real meaning, or whether it is a statement that breaks down when the person being charged is sufficiently powerful and politically connected. Prosecutors were effectively asking the jury to affirm the former, to say that the evidence is what it is, the law is what it is, and the fact that the defendant is a former president does not change the analysis. The defense was effectively asking the jury to consider whether this particular case, with this particular witness, in this particular political climate, was really the appropriate vehicle for making that historic statement. That meta-question about the appropriateness of the prosecution as much as about the specific facts was present throughout the closing arguments on both sides, even when it was not stated explicitly. When the closing arguments concluded, the jury retired to deliberate. 12 ordinary New Yorkers who had surrendered weeks of their lives to sit in judgment of a former president. They weighed the documentary trail. They considered the Cohen testimony. They evaluated the defense's attack on his credibility, and they reached a verdict. 34 felony counts, guilty on all of them. The jury concluded beyond a reasonable doubt that Trump had falsified business records as part of a scheme to conceal a hush money payment made to influence the 2016 election. That verdict was historic. Not because it resolved every legal question about Trump or established guilt across the full range of conduct that investigators and prosecutors have examined over the years, but because it was the first time in American history that a jury had looked at the evidence against a former president and reached a formal criminal verdict of guilty. The principle that no one is above the law was not just stated after that verdict. It was demonstrated by 12 ordinary citizens doing what the legal system asked them to do, evaluating evidence, applying the law, reaching a verdict. The prosecution's documentary case was designed to survive the Cohen credibility attack. This is the most important legal point of the entire trial. The prosecution did not build a case that required absolute trust in Michael Cohen. They built a case where Cohen's testimony about Trump's knowledge and intent was supported and surrounded by a documentary trail that they argued told the same story independently. Invoices, checks, ledger entries, internal records. Whether any particular juror believed Cohen completely was less important than whether every juror could look at documents and conclude that those documents established the elements of the offense beyond a reasonable doubt. The 34 guilty verdicts suggest that at least some of the jury, all of whom had to agree to convict, concluded that the documentary evidence was sufficient, even accounting for concerns about Cohen. The defense strategy of betting everything on Cohen's credibility was a calculated gamble that did not succeed. Todd Blanche's summation was built on a single argument: destroy Cohen, destroy the case. That argument had real merit as a legal strategy. Cohen is genuinely compromised as a witness, but the all-in attack on Cohen was a gamble because it did not provide the jury with an alternative explanation for the documents. It did not explain why the business records characterized Cohen's payments as legal fees rather than as hush money reimbursements. It focused entirely on undermining the key witness without explaining the paper trail that existed independently of that witness. And when a jury is looking at signed checks and internal ledger entries that appear to document exactly what prosecutors say they document, a strategy that focuses entirely on attacking a witness rather than explaining the documents is a risky one. The 34 guilty verdicts established a historic precedent that will shape how future prosecutors think about accountability for presidential misconduct. For the first time in American history, a jury found a former president guilty of felony crimes. That verdict does not resolve every question about Trump's accountability across the full range of conduct that investigators have examined, but it establishes clearly that juries can and will apply standard criminal laws to former presidents when the evidence supports it. It demonstrates that the principle of equal justice under law is not simply aspirational. It is operational. Juries enforcing it. Courts overseeing the process. The verdict will be studied and cited for as long as questions about presidential accountability remain part of American legal and political discourse. The clash between irrefutable evidence and scrambling panic captures the essence of what the trial was about. The prosecution spent 7 hours presenting what they called damning documentary evidence and asking the jury to convict based on the paper trail. The defense scrambled to make the case that everything depended on one witness who could not be trusted. The jury sided with the paper trail, and the result was 34 guilty verdicts that will be part of the permanent historical record of this era. Regardless of what happens to the sentencing, regardless of what happens to Trump's presidency, regardless of how every subsequent legal battle in the Trump accountability saga ultimately resolves, the evidence was presented. The jury evaluated it, the verdict was returned, and the history that verdict made cannot be unmade. The broader significance that the hush money trial verdict carries beyond its specific legal facts cannot be overstated. The trial was about business records and hush money payments, but what it meant, what it established in the public record and in the legal record, was about something much larger. It was about whether the American legal system is capable of subjecting its most powerful political figures to the same criminal accountability that applies to everyone else. For years, critics argued that Trump's legal troubles were all political, that prosecutors were targeting him for his political beliefs and his political positions rather than for genuine criminal conduct. The hush money trial tested that argument against a specific factual record. Prosecutors presented a specific documentary trail. A jury evaluated it. The jury concluded beyond a reasonable doubt that criminal conduct had occurred. That verdict, reached by 12 ordinary citizens applying standard criminal law standards to a specific evidentiary record, is the most direct possible repudiation of the witch hunt narrative. Not because the verdict proves everything Trump has ever been accused of, not because it resolves every legal question across the full range of investigations, but because it demonstrates that at least in this specific case with this specific evidence, a properly constituted jury reached a criminal conviction based on the facts. That is not a political outcome. That is a legal one. And the distinction matters enormously for how the accountability story of the Trump era is ultimately understood. The trial revealed something significant about the people around Trump and the organizational culture of the Trump Organization. The testimony and the documents introduced at trial painted a specific picture of how the Trump Organization operated that goes beyond any individual transaction. The hush money scheme, the payments to Cohen, the reimbursements disguised as legal fees, the internal records reflecting the false characterization, was not the work of one rogue employee acting without authorization. It involved multiple people across multiple levels of the organization. Alan Weisselberg, the Trump Organization's longtime chief financial officer, was involved in the financial mechanics. Rona Graff, Trump's longtime executive assistant, was involved in scheduling and communications. The scheme required coordination among people who knew what the payments were actually for and who participated in recording them as something different. That organizational picture of a business culture where falsification was a coordinated group activity rather than a solo act is part of what the trial evidence established. It has implications that extend beyond the specific hush money payments to questions about how the organization has operated more broadly and whether the patterns visible in this specific case are representative of broader organizational practices. The prosecution called their evidence damning. The defense called Cohen the greatest liar of all time. The judge told the jury to disregard part of the defense's attack as improper. And at the end of all of it, 12 ordinary New Yorkers looked at the evidence and said 34 times guilty. That sequence from damning evidence to scrambling defense to historic verdict is the story of American legal accountability being tested at the highest level and succeeding. Not perfectly, not without controversy, not without legitimate questions about specific aspects of how the case was charged and tried, but succeeding in the most basic and most important sense. A jury evaluated the evidence. They applied the law. They reached a verdict, and the verdict was guilty on all counts. That is the legal system working, not the political system, not the partisan system. The legal system with its documented evidence, its rules of procedure, its standard of beyond a reasonable doubt, and its ultimate authority, the judgment of 12 ordinary citizens working exactly as it is supposed to work. And that is the most important thing about the closing arguments, the verdict, and the historic precedent. They together established the system worked. The evidence was damning, and the verdict reflected both. The prosecution's decision to present a 7-hour closing argument, to walk the jury methodically through every piece of documentary evidence over the course of an entire day, reflects a specific prosecutorial philosophy about how to try a case of this complexity and this political sensitivity. They were not relying on rhetorical fireworks. They were not trying to create dramatic moments. They were doing something more deliberate and in some ways more powerful. They were showing the jury that the evidence was overwhelming, not just in quality, but in quantity. That the paper trail was not a single smoking gun document, but an accumulation of connected records. Invoices, checks, ledger entries, phone records, internal communications. Together, they created a comprehensive picture of a scheme that was documented at multiple levels and by multiple actors. The 7 hours were designed to make the jury feel the weight of the documentation, to make them understand that this was not a case where the prosecution had one piece of evidence and was asking them to make a leap. It was a case where the evidence existed at every step of the scheme, and the jury's job was simply to connect the dots that the documents themselves had already drawn. That prosecutorial approach, overwhelming documentation presented methodically over 7 hours, is itself a model for how complex financial fraud cases can be tried against powerful defendants who have the resources and legal talent to mount aggressive defenses. The 34 guilty verdicts suggest it was an effective model in this specific instance. The system worked, the evidence was presented, the jury evaluated it, the verdict was returned, and the history that verdict made will stand as one of the most significant legal developments of the 21st century.